السقوط والسيارات يتحدثون لغتكم، يحاربون من أجلكم. المحامي لورنس قاجي، الاستشارات مجانية ولا يستلمون أتعابهم إلا بعد إكمال القضية. زوروهم على 10000 West 9 Mile Road Suite 1400 Southfield. اتصلوا على المحامي لورنس قاجي 248-702-6641 248-702-6641.
أعزائي المستمعين، أهلا وسهلا بكم في برنامج المحامي لورنس قاجي. معي في الاستوديو المحامي لورنس قاجي. أهلا وسهلا. Welcome Mr. Lawrence قاجي.
Thank you so much. I'm so happy to be here today.
طبعا welcome Mr. John Shrodder.
Well, thank you so much for having us. Always a pleasure.
واهلا وسهلا بالاخت العزيزه الباراليغال الست مارا اللي راح تترجم لنا من العربي للانجليزي ومن الانجليزي للعربي. اهلا وسهلا بك.
اهلا وسهلا.
طبعا مستمعينا مشاهدينا الاكارم، الحلقه تنقل لايف على صفحه اذاعه صوت الغد، وايضا على قناتنا في اليوتيوب فيوتشر راديو ميشيغان. نحب انه تسوون سبسكرايبر دائما في سبيل انه توصل لكم هذه البرامج دائما مستمعينا الأكارم. طبعا تحدثنا بالأسابيع الماضية عن كثير من المواضيع، واليوم على أساس نكمل في نفس المواضيع. الأسبوع الماضي ما كان معنا المحامي جان شرودر، كان معنا محامي آخر، واليوم نتشرف بوجود المحامي جان شرودر. Yes.
We are gonna begin today with finishing what we did last week, what we were talking about the Supreme Court with a new law or new law coming out. Also, we missed you, John, last week, so welcome back.
Thank you. It's great to be back.
Let's just say that we all missed John last week.
Yes.
He put a lot more work on myself last week than I anticipated. It's okay though.
Yeah.
Well, I'm happy to be back. Yes.
And welcome back, John. Hopefully you had a nice time off.
Yes. It was very nice. Went up north. Enjoyed a little bit of the sun and the beaches, which was nice. So with the family.
طبعا راح نكمل اليوم اللي تحدثنا به الاسبوع الماضي لأنه ما خلصنا بصراحه.
الاسبوع الماضي بدينا بالموضوع اللي هو المحكمه العليا، اكبر محكمه عليا، السبريم كورت. طلعت قانون جديد.
نعم.
اذا واحد يعني عثر ووقع or زحلق. So هذا قانون جديد, and we are going to begin talking about the new law for the Supreme Court for the slip and fall.
Yeah, so Tamara, as you mentioned, there is a new case that came out from the Michigan Supreme Court. And just to remind the listeners what our Supreme Court is, essentially, we have a court system in Michigan that, obviously we have statutes and things of that sort, but we also have case law that guides our principles here, our legal principles. We have our trial courts, which is our circuit courts in Michigan. We also have our appellate courts, which is, if something needs to be appealed, goes to our appellate court. And the highest court, like I said, is our Michigan Supreme Court. As I mentioned a couple weeks ago, we do have a case right now in the Michigan Supreme Court that we are litigating. And we'll see what happens with that case. But a very interesting issue up on.
Yeah, you said it will take time. And
yes.
A lot of lawyers will benefit from
a lot of time. This action that we have, with the Michigan Supreme Court, I think was a 2019 accident, and because of the issue, because it's gotten so high up, obviously we're 4 years from the accident date, and we're still litigating it. So that does happen sometimes, where we get some legal issues that we have to get worked out by the Court of Appeals or the Supreme Court. And, the court systems are not the fastest thing in the world. So kind of is what it is, right?
It is what it is, yes. مثل ما تكلمنا بدينا نتكلم الحلقة الماضية بأنه بالميشيغان أكو عدة محاكم. المحاكم اللي بكل مدينة طبعا. بعدين تصعد المحاكم اللي هي الابيل كورت، اللي هي المحاكم
من جددون، يعني انه شو اسمه
I lost my word.
اعتراض نعم.
يس شكرا. وعندنا المحكمة العليا
نعم.
كلش اللي هي سبريم كورت.
Yes.
السبريم كورت هي اختصاصها بأنه تعطينا القوانين الجديدة.
نعم.
هي اللي تسوي القوانين للميشيغان.
نعم.
نعتمد عليها بالقوانين اللي تطلع الجديدة. وعندنا مثل ما قلنا احنا بالمكتب مالتنا شخصيا عندنا قضيه من 2019 هي صايره الحادث.
نعم.
وهسه هي بالسبريم كورت، لان اكو مرات بعض القوانين لازم يعني هم يقررون بانه تمشي لو لا. ان شاء الله نخليكم على علم من نحصل على النتيجه
ان شاء الله يا رب.
So how do these cases get up to the Supreme Court? You know, there's usually a legal issue, right, that needs to be decided. And what the issue was in this case, it was a slip and fall case. So everyone kind of knows what a slip and fall case is, right? There's a fall. There's an injury, and there should be some sort of negligence on behalf of the owner, invitee, whatever you want to call them.
Mm-hmm.
So that's what this issue was, and the issue was what we call the open and obvious doctrine, which I'll explain. So that was what was litigated, and that's why it got up to the Supreme Court, which I think was much needed.
And we'll go into the facts of the cases a little bit in a moment.
القضية مالتنا همينا بأنه اللي عندنا ويا السبريم كورت همينا لأنه الشخص وقع بمكان.
نعم.
والقضية بأنه هل هذا الشيء كان واضح بأنه يقدر يوقع لو كان ما يدري. فرح ندخل بالتفاصيل شنو اللي هسه تغيرت القوانين.
So let's just start with the history, right?
Yes.
So the history was before 2001.
Yes.
There was slip and fall cases where someone would slip on ice or on water, and they would essentially have a slip and fall case against the business, right?
Yes.
In 2001, a case came out from the Supreme Court as well, called Lugo versus Ameritech.
Right.
It was a Supreme Court case, correct?
Yes, it was a Supreme Court case, Lugo versus Ameritech, 2001. Yep.
Right. And essentially said that if something is open and obvious, so ice, for example, water, black ice, things of that sort, if you can see it, you don't have case. The owner doesn't have a duty to warn or do anything against that sort of harm.
Yeah. So قبل 2001 القانون كان إذا تزحلق بمي لو بثلج لو بسقيع يعني مي ثلج مي جامد عندك قضية لأنه تزحلقت
قبل 2001.
نعم. ورا 2001 السبريم كورت طلعت قانون جديد بأنه إذا فشي واضح، إذا الثلج واضح والمي واضح ودا تشوفه وتزحلقت أبو المكان اللي يعني وقعت بيه بعد ما له داعي يخلي أي إشارة بأنه دير بالك أكو مي لو دير بالك أكو ثلج وماكو قضية بعد إلك.
And if I can add to that just a little bit, the background of Lugo was that the plaintiff claimed she was in a parking lot, of a business, and she claimed that she fell into a pothole and injured herself, and so her suit was against essentially the owner of that parking lot.
اوكي. القضيه بانه هي كانت بانه الشخص وقع بنقره بحفره بالباركينج لوت
شوبينج سنتر
بالضبط.
نعم.
اي القضيه بانه هي رفعوا القضيه ضد الاونر مال الشوبينج سنتر بانه هي وقعت بالحفره.
So after this case came out, it essentially wiped out like 80% of the slip and fall cases.
Right. And because the court decided that the pothole itself was, to the average person, easily observable. She could have seen it if she, had looked straight down at it, seen it. It was open and obvious, and therefore there was no duty. That's what the court decided. There was no duty to fix the pothole, or they had no duty at all to essentially protect people from harm in the parking lot if what the harm was caused by was quote unquote open and obvious to the average person.
Right.
المحكمة قررت بأنه الحفرة كانت يعني كبيرة والشخص الطبيعي يقدر يشوفها، فهاي فشي للنظر كلش واضح، فقالوا ماكو قضية ما مجبور أبو الشابينج سنتر يحط أي علامة أو يسدها أو يسوي لها أي شيء، لأنه هي ما هي كبيرة ماكو داعي يسوي يعني لها أي شيء. مبينة بالضبط، فشي واضح ومبين للعين المجرد.
يعني أنت بدك تشوف حفرة تعذب نفسك بيها
بالضبط. بس مرات مثلا واحد بده يحكي ويا أحد، لو مثلا مسواق بيده لو ملتهي وما يشوف، المفروض الشارع عدل، المفروض
صح المفروض.
Yes.
And actually, if you don't mind, just briefly, the reason that's important is because in order to present a claim for an injury like this, a premises liability claim or a claim based in tort, you have to have essentially 4 elements. You have to have a duty, a breach of that duty. Okay, you have to establish that their breach of duty was the cause of your damages, and then you have to have damages themselves, i.e. the injury or medical bills or something like that. So you have to have duty, breach, causation, and damages in order to have a claim. So by the Supreme Court saying there's no duty, all the claims are immediately gone.
Yeah.
لأن على مود عندك قضية لازم أنت تكون متضرر ويكون عندك الشخص اللي تضرر به المكان، ابو المكان لازم يحط مثلا علامات تحذيريه. اذا ماكو وحده من هالاشياء ما عندك قضيه.
So just another kind of history background. So John, there's been some changes, right, in our Michigan Supreme Court with the judges. Right?
Yes.
So not to sound
judges are elected here,
right?
So over the years it changes,
right? So for the longest time, in my opinion, we had a Michigan Supreme Court that was more defense friendly, meaning they were more friendly towards insurance companies, business owners, landowners, things of that nature. And I think it was really good timing for us. We had 3, I remember if it was 2 or 3 new judges that were elected recently that were more plaintiff friendly than defense friendly, in my opinion. And I do think that their opinions kind of helped us get this new case that we're going to be discussing in just a moment.
طبعا بالعالم كله عندك يعني فريقين، خلينا نقول فريق ضد وفريق معه. هذا الفتشي العادي. فكان السبريم كورت المحكمة العليا كانت كلش ويا أهل الانشورنس، ويا الأونر، ويا الأونر مال المحل، مال المكان، وضد المتضرر نفسه، ضد المحامين، ضد هالاشياء.
نعم.
قبل كم سنه ورا elections yes اللي هي انتخابات. بالانتخابات شويه هسه تغيروا، جو 3 حكام جدد اخرين هم ياخذون يعني من صفحه المتضرر وكذلك المحامي.
Right. And so, what happened was this open and obvious issue kind of, made its way up to the Supreme Court. And we finally got a decision back. It was a 5-2 decision. And the Supreme Court ruled in favor of the plaintiff. And it essentially abolished the open and obvious doctrine in Michigan.
Yeah.
And it's a case against Kroger. What's the case?
In 2 cases. There's it's actually combined 2 cases, and it's Alam Kandil El Sayed versus F&E Oil is the first one. That's relating to a gas station claim. And then the second one is Pinsky versus Kroger. And that was a claim within a Kroger supermarket, essentially.
Yes.
Okay. Can I just read this?
Oh, sure.
اوكي القضيتين هسه اللي صار بشهر الخامس.
نعم.
المحكمة العليا اكو قضيتين، قضية احلام قندل السعيد ضد غاز ستيشن.
نعم.
واكو اللاخ بينسكي ضد كروغر.
نعم.
اللي هم هذول همين مزحلقين وواقعين. فالمحكمة غيرت القانون
يعني في
شوية.
بداية في البداية قبل هذا القانون، قبل التغيير كان اكو انه هذول ما عندهم كيس
for
ما
20
عندهم
for 20 plus years.
اكثر من 20 سنة
بالضبط.
ماكو عندهم كيس.
تقريبا
بعدها
22 سنة صار لهم إذا الأوبن ان افيس، إذا المكان تشوفه زين ومثلا مشبوب دهن.
نعم.
لو مي لو أي شيء وتزحلق يقول لك لا هذا تقدر تشوفه بالعين المجردة وما
نعم.
عنده قضية.
نعم.
هسه من شهر الخامس ورا هاي القضيتين اللي صعدت للمحكمة العليا
نعم.
غيروا القانون.
Now, just to be clear, this decision doesn't close the cases and rule definitively in favor of the plaintiffs, but rather it leaves them the ability to go to a jury to determine if there is if there are damages.
هذا الكيس هو قديم 20 سنة. شلون انفتح مرة
So
ثانية؟
that's exactly how it goes, right? So the plaintiff attorneys, they think that, hey, this open obvious doctrine it's not right. We don't think that this is right.
Yes.
We're going to appeal it. And then
this is the reason for appeal.
This is the reason.
Yes.
There's been a ton of appeals, but finally
These two are the
Right.
first. Yeah.
they're not the first, but they're the ones that actually
The
got
ones
heard.
that you are.
Yeah, because it's up to the Supreme Court on what they want to hear.
Yes.
Essentially, they finally heard this issue.
مثل ما تفضلوا بأنه صار أكثر من 22 سنة.
نعم.
بدوا المحامين يعترضون اعتراض ورا اعتراض ورا اعتراض.
نعم.
وأخيرا شافوا هاي القضيتين صعدت للسبريم كورت.
نعم.
الاعتراض أخذوه نجح.
نعم.
فصار غيروا القانون
على
بأنه بالضبط على مود هذول الاثنين. مو معناته بأنه القديم بعد ما يصير،
لا باقي.
مو باقي. لو خلص عنده قضية، لا لازم تروح عن خلال هيئة المحلفين وهم يقررون. الجوري بالضبط.
So actually, and just a tiny bit more background on this, because I think it is important. So initially, again, before this case, the Lugo case was overruled. Okay. Essentially, someone had to say that there was some kind of special aspect to the premises, okay, which would have allowed a plaintiff's claim to continue. In that the plaintiff's attorneys actually did argue that, right? So in the gas station case, when the plaintiff slipped and fell at the gas station, the plaintiff argued that the snow and ice on the premises constituted a dangerous condition, and that and that because the condition was effectively unavoidable, they should still have a claim. Whereas defendant, under this prior doctrine, all they had to say is, no, it was open, it was obvious, and there's no special duty of care because it wasn't unavoidable. She didn't have to stop at the gas station at all.
Okay. So واحدة من القضايا اللي هسه قلنا لها أعتقد مال غاز ستيشن، بأنه هو كان أكو ثلج ومي وتزحلقت ووقعت. فهي الاعتراض مالتها بأنه غلط، كان المفروض أكو فد علامة تحذيرية. ما كنت أقدر أحط مثلا بنزين بأي طريقة أخرى، لازم أنزل وهذا كانت خطرة لأي أحد مو بس إلي.
صح.
كان قبل بأنه يقول العفو ما عندك قضية، هذا الثلج واضح ومفتوح وأبو المحل ما مجبور يحط لك أي علامة بأنه أكو يعني تحذير.
Yeah. And then in the Pinsky case, it was a string that was hung from a counter, basically closing a checkout lane. Whoa. That the person fell over, okay, and injured herself allegedly. And the defense said, again, if you looked at it, you would have seen it was there. It's basically, for all intents and purposes, we have no duty because it was open and obvious. And they said, well, it's unreasonably dangerous, which is another exception to that open and obvious doctrine. And, you know, again, in both of these cases, the appellate court said no case.
القضية الأخرى اللي مالك روجر بأنه من يم الكاشير كان أكو زنجيل يسدوه حتى لا حد يمشي. الشخص فات وأثر بيه ووقع. فالمحكمة قالت ما عندك قضية لو شايفة كان ما فتت المفروض منك وكان ما وقعت وما أبو المحل ماكو داعي يحط تحذير. Okay.
Yeah. So, so what I think is going to happen now. So, John, do you think that this is going to be applied retroactively? So, meaning, even prior to this opinion, all the slip and falls that happened prior to are still going to be okay.
So I guess it depends on. There's always a statute of limitations, right? So as long as you comply with the statute of limitations, this case has now been overruled. So and it's
Which
not
is 3 years in Michigan, right? Slip and falls, or is it?
So generally speaking, so it depends on the type of case. I think generally speaking, there are different types of cases that have different statute of limitations, and it depends on if there are other factors involved. Like, for example, if there's an auto accident or anything like that. But generally speaking, yes, it's a 3-year statute of limitation in Michigan for a slip and fall or premises liability type case such as this.
So essentially, if so now that the new decision's out, a lot of people, a lot of potential clients have called my office or other law firms, and they have gotten a rejection. Right? They call on a slip and fall case, and they say, you know, hey, I'm sorry, but we're not going to be able to help you.
Right.
And it's probably because of this decision or this doctrine.
Because of the old doctrine that's
No
now
doctrine,
overruled.
right.
Yes.
So I was going to tell the listeners, if they do have a slip and fall case that happened within the last 3 years,
right,
and they had a case that was rejected in the past, they probably have a case now.
طبعا قبل ما اذكر اللي قال المحامي لورنس، اي واحد عنده سؤال عنده استفسار يقدر يتصل بينا الان على 586 825 2015 لاي سؤال اي استفسار. ومكتب المحامي هو 248-702-6641. يقول المحامي لورنس، سوري من رخصتك، اي واحد عنده كيس عنده سقوط او سقط خلال ال3 سنوات الماضيه، انه صار عنده وقع امام ستور، وقع امام والمارت ولا في مكان من المكانات هذه، عنده كيس يقدر يتصل بالمحامي لورنس قاجي على 248-702-6641. اي واحد خلال 3 سنوات الماضيه، يعني من هسه الى ارجع 3 سنوات، تمام؟ هذا فيقدر يتصل. واللي عنده سؤال استفسار الان يقدر يتصل بينا على 586-825-2015. الحلقه تنقل لايف على صفحه اذاعه صوت الغد، وايضا على قناتنا في اليوتيوب، والارقام موجوده على الشاشه. يس.
مثل ما تفضل اول محامي بانه القانون تغير، هسه بعد ماكو شالوا بانه هذا واضح وتشوف العين وما عندك قضيه. مثل ما تفضلت اللي عنده من شهر الخامس قبل 3 سنوات من شهر الخامس اللي عنده قضيه، لان هي هاي ليش نقول 3 سنوات؟ لان هي هاي قانونيا عندك بس 3 سنوات حق حتى ترفع قضيه فقط. اللي قبلها مع الاسف خارج نطاق الوقت، فمعناته ماكو بعد قضيه انتهى.
السؤال للمحامين، اذا انت مسوي كيس، عندك كيس قبل مثلا 10 سنين وما مشى، يقدر هسه يفتح حق اطلاق؟
لا.
It sucks, honestly.
What's the question? I'm sorry.
He said, if you had a case 10 years ago, can you reopen it now?
No, there's still an absolute bar of statute of limitations.
So imagine how many cases for the last 20 years could have been a case and could have recovered money from the insurance companies. but they had 20 years of this protection, but not anymore.
For 3 years it's okay.
Yeah.
The previous.
Yes.
مع الأسف اللي بس لأنه قانونيا عندك 3 سنين بالضبط فقط.
But I understand your question. Like, how is that fair? If the law just changed, I didn't have a case 5 years ago, but I do have a case now, but I can't pursue the case. How is that fair? And that's just kind of just how the law works. It's statute of limitations.
يعني مثل ما قلنا كل بلد له قوانينه وهذا القوانين تطلع وكل فترة وهذا اللي نقدر نسوي ما نقدر نسوي أي شيء آخر.
نقدر نرجع 3 سنوات.
Yes.
Yeah, the basis, or at least the concept behind a statute of limitations, is that as people are removed in time from the event that occurred. So if something happens, yesterday, you might remember it very well,
Yes.
right? But if something happens 6 months ago, you might remember it less well. And the idea behind a statute of limitations is to say,
10 years or 5 years?
right. And the idea is, well, wait a minute, how well do you really remember the facts? How well can people testify about things that happened 3, 5, 6, 10, 20 years ago? And so the statute of limitations, at least the concept behind it, whether you agree with it or not, and there are different statute of limitations for different
Most of the people
issues.
now are Alzheimer.
Fair enough. I don't know about that, but what I can say is the idea is it's to prevent claims from being very old, essentially litigated or relitigated, when people don't have the ability to even defend themselves because they don't remember what happened anymore.
John, we practice that every day. We have people coming for a car
Yes.
accident, which
Yes.
happened last week, and they say, "Oh, it happened somewhere last week on a Wednesday." They don't even remember what day it was.
Right. And so imagine, and it was
Imagine 5 years.
5 years. Yeah.
exactly.
Yeah.
So John has his own theory. I have my own theory about why there's a statute of limitations. And I think it's just because the courts don't want to have a million cases. Because if you can file a slip and fall case for the last 20 years, there would be a lot more cases filed right now than.
I mean, and that's fair too.
So
And
I think it kind of prevents the courts from being overloaded with very old cases, and
and
you have your time to sue.
And there's an economic aspect to it as well, right? If you're a business, and you're going to be subject to liability for things that happened 40 years ago, and the law changes and affects cases that could have occurred 40 years ago, all of a sudden you might have multiple millions or billions of dollars of liabilities that you didn't have yesterday, and that can cause economic disruption. So there are quite a few theories as to the justifications for statute of limitation.
الستاتيو اوف ليميتيشن اللي هو المده المحدده اللي ترفع قضيه. كل طبعا الكل
كل قضيه
مو قضيه
لا.
كل نوع قضيه لها مده معينه بالضبط. مثلا السياره، حادث سياره، حتى ترفع قضيه ضد الانشورنس الشخصي مالتك عندك سنه واحده. بس إذا ضد اللي ضربك وأنت ما غلطان عندك 3 سنين. عندنا مثلا الميديكال مال براكتس اللي هي الأخطاء الطبية عندك 2 سنين. السليب اند فول 3 سنوات. فهاي كلها تعتمد طبعا دارسيها ودراسات تعتمد على هواية أشياء، وكل واحد عنده وجهة نظر تختلف عن الآخر.
صحيح.
Right. So now we were talking about slip and falls, right?
Yes.
And we were talking about essentially that there's a duty of care that are owed to these individuals who are on these commercial properties, right?
Yes.
So there's actually a specific legal term for this. They're called invitees. And the interesting thing about slip and falls is that, or premises liability cases, is that there's actually 3 different categories of people, each with 3 different levels of protection. Okay. And I'll explain those after.
بالنسبة للحوادث الواحد يتزحلق ويوقع بها يعني مو همينة بس وقعت وخلص، لازم أكو أشياء تثبتها وأكو أشياء يعني ملموسة. هي 3 أشياء وراح يتفضل المحامي جان يشرح لنا إياها.
Now, what this specific case we were talking about earlier in the program was referring to was for those people who are called invitees. Okay. Mm-hmm. And invitees are those people who are on a premises, okay, that's held open for a commercial purpose of some kind. So for example, if you're going to the supermarket, if you are going to a gas station, right? If you are going into an office building, right? Those are held open for commercial purposes. And so when you go into that building or onto that premises for a commercial purpose, i.e. to use that business, you are considered an invitee. And that actually has the highest level of protection under the law.
اوكي انفايتي بالضبط شنو انفايتي اللي هم احنا نقول بالعربي المعزومين. المعزومين هم بانه هي اذا تروح الى محلات يعني مثلا تروح للغاز ستيشن، تروح تتسوق، تروح المكتب، هذول انت رايح تسوي شغل هناك، رايح تاخذ من عندهم شغل، تاخذ لهم شغل بالضبط.
نعم.
فانت معزوم لهذا المكان تروح له، هذا يسموه طبعا هذا
المفهوم
بالضبط اللي يسهل حتى
المستمع والمشاهد يعرف
بالضبط. هذول الانفايتي لهم بروتكشن عالي، حماية عالية لهذا القانون، لأن هم أكثر الناس اللي يتعرضون للضرر.
صح. And the question you might ask is, well, why do these have higher protections? Well, because for a business, right, you're going to have people coming on that premises all the time. Right? I mean, if you're holding yourself open to the public for business and people are coming onto your property all the time, the concept, at least in the beginning, was supposed to be you have to have a higher duty to make sure your premises is in good condition so that people don't get hurt all the time coming in. So what do they? So they essentially the invitees are owed the duty to maintain the premises in a reasonably safe condition. At least that's the first aspect of it.
أولاً اللي لازم هسه يسووه، لأنه أنت الفاتح الشغل والبزنس مالتك حتى الناس تجي تستفاد. فمثلا مايرز ولا والمارت هذول مفتوحين
24 ساعة.
Exactly. Right. So they are always open. لا أولاً خلوا القرار بأنه لازم تأخذ يعني تكون مالتك المكان جاهز ويعني وسليم للناس حتى لا يتأذون.
Right. And they similarly have a duty to protect them from an unreasonable risk known to the possessor of the property. Like, for example, if there's a giant, pit in the middle of their floor where people are walking all the time, and they put a little carpet over it, and people are just going to fall in, and that's almost cartoonish, right? But you can't just leave that open there and expect people not to get injured, right? So you have to, if you know about a risk for the property, or you should have known about it, then you have to exercise ordinary care to protect the invitee. If there are dangers, you have to warn them of dangers. And they also have a duty to inspect the premises to determine if there are dangers. So you can't just be like, well, I haven't been there in 6 months. I don't know if there were any problems with the property.
Maybe after the 6 months and one day what happened.
Or maybe during that 6 months, right? So so there's
مثلا إذا أكو أبو المحل لازم يكون حذر ويكون جاهز ومجهز مكانه حتى ماكو أي خطر للناس الحاضرين اللي راح يجون يزورون المكان أو المكتب أو يسوقون المحل مالته. لأن ولازم دائما مو بس داخل الخارج همينه، وأكثر شيء الأونر اللي هو الأونرز ما موجودين دائما بالمكان. بس لازم دائما يروحون ويشيكون المحلات من الداخل ومن الخارج أن تكون سليمة للشخص اللي يجيهم.
Right. Now, the next type is a licensee. So what if you just have a guest over your house? Do you owe them any duty? The answer is generally yes. If you invited them onto your property, or if they have implied consent to be there. So for example, someone comes over and you don't kick them out, right? They're not trespassing. Then that's considered a licensee on the property. It's a lower level than an invitee as far as duties go, but you still have a duty, generally speaking, to that person to prevent injury.
Is that like on a
so that's like, yep. So that could be private property. So let's say your home specifically,
Yeah.
right? You own a home. You have a friend over. Okay, that friend is considered a licensee under the law.
اوكي اللايسنسي كانما واحد عنده لايسنس عنده بطاقه او اللي هو يحق له بانه يجي يدخل بيتك. هذا ابسط مثال. اي احد يجي يدخل بيتك يكون بيتك جاهز حتى ما يتاذى الشخص اللي الخطار اللي يجيك مثلا.
مو شرط خطار يعني
اي احد يجي يدق الباب،
ابو الكهرباء،
ابو البريد،
نعم.
اي احد. فلازم دائما تدير بالكم بانه ماكو شيء بانه يتاذى.
So another example might be a church. Actually, there's a case in 2000 where the court decided that you are a licensee when you enter a church. Okay, you're not necessarily there to buy something, right? It's not a commercial entity per se, right?
You go to pray.
Right. So although there is a lot of money exchanged, at churches, you don't have to go into the church for the specific purpose of buying something, right? So it's not necessarily a commercial purpose, but nevertheless, you're still a licensee when you go into a church, and that church will still owe you a duty. And the duty is that if they know about or should have known about a dangerous condition on the premises and it presents an unreasonable risk of harm, they shouldn't just expect you to know about the danger. They have to essentially take some action. They have to exercise reasonable care, okay, to make the condition safe or warn the licensee of the condition or the risk.
المثال الآخر عندنا إنه أنت تروح للكنيسة أو المعابد، أي معبد. لازم هاي ما تروح هناك تشتري لو تتبضع، تروح بأنه تؤدي واجباتك. لازم أبو المعبد يكون همينه كلش يكون جاهز ومكانه جيد وما بي أي خطر لأي أشخاص اللي يجوا.
So what's a little bit different about this, right, is, if it's in your home or like a church or something like that, you might not necessarily have the same level to maintain the premises in perfect condition. So like, let's say your front porch step just started crumbling away and you haven't gotten a chance to repair it yet, right? So if you haven't had a chance to repair it, you might warn the person, say, hey, don't step on that step, come around the back way, okay? And then you should be fine. But I think the concept is you don't warn them it's falling apart. You know about it, that it's falling apart. You don't tell them anything. And you're like, hey, you should go step on that step. They fall and they hurt themselves. I mean, it doesn't require that last part. You don't have to actually tell them to go step on the step. But the idea is you know about the condition. You don't do anything. Then you could still potentially be liable under a premises liability, under the premises liability law.
الفرق اللي بين المكانات العامة والمكانات الخاصة، مثلا العامة مثل الأسواق والأشياء، والمكانات الخاصة اللي هي البيت والكنيسة. البيت والكنيسة بأنه مرات أنت ببيتك عندك الدرج اللي دخلت البيت مثلا انسلمت،
مكسوره في
الطابوقه من هذا وما صار عندك وقت، فانت اللي عليك تنبه اي احد يجي بانه دير بالك اكو، هذا كافي بانه تنبه. بس اذا ما تنبهه ذاك الوقت عندك قضيه ضدك.
So again, we're talking about slip and falls, right? Yes. And we're talking about, we've got the invitees, right, for the commercial purpose. Yes, we've got the licensees, which is for basically a non-commercial purpose. And then we've got a third type.
Yes.
Trespassers. What if someone trespasses on your property without your knowledge or consent, at least, right?
What if you don't want them to be there?
Do you still owe them a duty? That's an interesting question. Do you? It's my question. It's a question I pose. What do you think?
I think no.
Great. So you would be right some of the time.
Yeah, because maybe he came there to steal something.
What if he
break the house?
What if he's breaking into your house? Exactly.
Right.
What if he came to break into your house?
So for sure you owe them the lowest duty of care. But what if that trespasser was a minor child and there was a dangerous condition on play equipment that was easily accessible to them right near your house that you didn't maintain, might that change your mind?
So let's say a kid comes from 2 doors down
Yes.
and comes to your house where there's some sort of danger.
What happened?
Something happened.
Yeah.
Right.
Right.
Okay, what about if you have like someone came in and you have a dog, he bites him?
Well, that's
This is different.
that's a dog bite case, and I'm not prepared to talk about that today. So maybe another time I can talk about that. I will say this though, generally speaking, if there's an undiscovered adult trespasser,
Yes,
right, then you generally don't, and the owner doesn't know about the trespasser's presence, right, and you really couldn't have known about him. He just comes onto your property, right, without permission. You didn't know about it ahead of time. Then you generally don't have any duty. Okay, but interestingly, it changes when you discover them, and it can also change when there are children. So I'm not going to go into all the specifics because there's a lot of case law over that, but suffice it to say that if it's a trespasser, that's the lowest duty that could be owed to any, for any premises liability case.
trespassing إذا أحد إجا تعدى على بيتك اللي هو أنت ملكك ويجي أحد غريب يطب عليه بدون علمك، هذا يسموه trespassing. إذا أحد إجا ومثلا خلينا نقول أنت عندك كرسي برا ومكسور ووقع، أنت ما مخول، ما يقدر يرفع عليك قضية لأنه هو دخل بيتك من غير إذن.
Now here's what's you're not finished. I'm sorry.
I'm not finished. طبعا يتغير من الموضوع إذا بها أطفال، ويتغير الموضوع همينة إذا it was children and what again?
So there's adults adults that are not discovered. There's a discovered trespasser, and then there's child trespasser.
وأكو همينة إذا أحد غريب إجا وعلمت بأنه إجا وتعرف وتحذره، هذا احتمال أكو قضية. والأطفال همينة غير شكل، قوانين كلش هواية، وإذا ندخل بهالموضوع تفاصيل جدا جدا طويلة. So كل شيء إلى يعني level معين.
Yeah, and just one of the things that comes up is, can you essentially set a trap for a trespasser and then injure them, right? Like set up a shotgun to shoot them or set up a bear trap to trap them. And the answer to that would be no. And you could still be liable for that because that's the context in which owners may still be liable for injury to people who trespass on the properties. You're not allowed to set up traps and injure people. Okay. There are probably other exceptions, but that's the major one that I can think of.
I remember reading a crazy case there's a law school case that every student has to read where, a guy sets up a shotgun trap, as soon as for trespassers who enter his property. And the courts have said, no, you can't just do that. So even though they're trespassing, there's still some duty not to create an unreasonable risk of harm.
مثل ما قلنا الترسباسنج بين واحد يجي يتعدى بدون علم ابو البيت، صاحب البيت. قسم قاموا يحطون بانه يحطون مثلا بندقيه، اذا احد اجى تنضرب له يحطون مصياده مع الرجل، هاي ممنوع. هاي عندك يصير قضية ضدك وما يصير تحط هالأشياء، فمنعتها المحكمة بأنه أنت تحط أي شيء.
You have to write a warning,
maybe warnings, signs.
I don't think you can. I still don't think you can have a shotgun trap, even if you have a warning sign. I'm afraid that's still probably not a good idea. I would not recommend it.
That's probably the only case I remember reading from.
There are a few.
That class.
But yeah, exactly. So I'm going to go with no on that one. That would be my best guess. But I'm going to bring this back around to what we were starting to talk about, right? So at the very beginning, we were talking about this change in the case law. Now that we've talked about the fact that there are invitees, licensees, and trespassers, right? And you know that trespassers are the least protected. Invitees are the most protected. Keeping in mind that the prior case law said that anything that was open and obvious for an invitee, that's the most protected class. You couldn't make a claim if you could see a danger.
Right.
at all. But for the most protected class, that's what the law was until July 28th of this year. Right? That's interesting. So the most protected class,
You think you're being protected, but then there's
the most
defense.
right, the most protected class of people who are entering onto properties really, I mean, in my opinion, this is my opinion, but they basically didn't have much protection at all.
I mean, like I said,
So-
it wiped out 80% of the slip and fall cases.
Do you have such
Yeah.
a case like this in your office?
So, so there, I have during my practice, I have done some slip and fall cases,
Yeah.
and almost all of them I've had to reject based on this. Okay.
So essentially, this is a new area that's going to kind of open up for everyone. And obviously, if the listeners have been with us for a while, they know that, you know, we are a personal injury firm. We do specialize in car accident
We do,
cases.
Yes.
Which, John, maybe we can talk about how
Yes.
slip and fall and car accidents kind of combine.
Intersect.
What
Yeah.
if you're getting out of your car and you slip on some ice?
Yeah, this is what happened
Right?
for the gas station. The
Yeah.
lady was
Right.
Yeah.
So what's the interplay between them?
I have no
Interesting, right?
It is.
Right. Well, and that's exactly right. So we have in Michigan the No Fault Act, and just to remind the listeners who haven't, listened to us day in and day out every week here, the No Fault Act is generally there to protect people from incurring medical bills. You have to purchase auto insurance. That auto insurance gives you protection from anything related to an auto accident. So then the question comes into, well, what if, right? You are not in a traditional car accident where you're driving on the road and a car hits you, but what if you are parked, right? And maybe you're fueling, maybe you're doing maintenance on the car, what happens then?
مثل ما قلنا هاي الثلاث طبقات اللي ذكرناها
نعم.
اللي لازم هم يكونون عندهم تغطية أعلى طبقة اللي هي كانت المحلات.
نعم.
هاي أعلى طبقة وأكثر حوادث تصير
بيها.
كانت 80% من هاي القضايا ما ياخذوها لأنه على أساس الشيء مفتوح وتقدر تشوفه. من جولاي 28 تبدلت هاي الهسه. الكل يعرفون اعتقد بانه احنا نسوي حوادث سيارات.
صحيح.
بس شنو العلاقه بين حوادث السيارات والسقوط؟ مثل ما هسه انت قلت هاي المره كانت واقفه يم سيارتها تطلع ونزلت وقعت. مثلا واحد واقف برا يم سيارته دي يصلحها ووقع. ايش راح يصير هسه؟
اي هذه يعني
exactly.
Right. You'll explain this, right?
Yeah. So it's an interesting area of law, and generally speaking, if you're inside your own vehicle, right? If you're occupying, entering into, or alighting from the vehicle, that's the statutory term. Okay. So if you are inside the vehicle,
so if you're as a general rule, not even talking about slip and fall cases, if you injure yourself getting in and out of the car, that's considered a no fault case.
Right.
So that just generally speaking,
bingo. Right. Which means your medical bills are going to be covered by your auto insurance.
Okay. شيء ملخص وقطعي وجدا واضح. إذا أنت تصعد من سيارة أو تنزل من سيارة وتأذيت، أنت عندك قضية ضد الإنشورنس مال السيارة مالتك.
نعم.
هذا فشي قطعي وواضح جدا.
نعم.
So from an auto perspective, let's take the gas station example. I think this is a good one. Okay. So let's take the gas station example where a person gets out of their car. Okay. They slip as they're exiting their vehicle. Okay, they slip on snow and ice that's on the premises. Okay, there are two potential aspects to this case. There isn't another car involved. I think we can all agree to that, right? So there isn't another vehicle owner that you could sue for the purposes of claiming bodily injury, right? But what you could do,
you can sue what?
But what you can do is if you are injured in alighting from that is exiting your vehicle, your own insurance company is supposed to protect you from the incursion of medical bills. So essentially the economic damages, okay, which could be wage loss, assistance around the house, and your medical bills, those are things that are generally going to be hopefully purchased by you under your auto no fault policy, and you'll get paid for that.
This will go again to have limit of your policy.
So yes, and yep, and we've talked about this in prior weeks where there are PIP limits, and we encourage people to purchase high PIP limits for exactly this type of reason. You never know how you'll be injured.
مثل ما هسه قلنا احسن مثال اللي هو انت بالغاز ستيشن تريد تحط غاز وتطلع من سيارتك وتزحلقت بنزين بثلج باي شيء. اولا الها هاي فرعين. الفرع الأول بما أنه أنت تنزل من السيارة معناته هي حادث سيارة، بس ماكو سيارة أخرى حتى ترفع قضية ضد. أوكي كل العلاجات مالتك، الرواتب، المساعدات البيتية، كلها راح تكون عن طريق الانشورنس السيارة.
Right. So, but now let's take that same situation, right? They've gotten out of the car and they slip and fall. So now we get to this interesting new situation that we didn't have just a few weeks ago, right? So they've now gotten out of their car, they slip and they fall. A few weeks ago, they would have had a no-fault claim. As far as an auto claim goes, that was there 3 weeks ago and it's there today. But what's changed is that they may now also have a bodily injury claim for essentially whatever the excess economic damages or non-economic damages, that is pain and suffering.
So 2 weeks ago, she didn't have a slip and fall case, and now this person does.
And now she might. She might. And I'm going to explain why she may. Why they could and why they might not. Okay, go there.
مثل ما قلنا هي طلعت من السيارة قبل أسبوعين ما كان عندها كيس لأنه تزحلقت ووقعت. القضية اللي إلها هي ضد أبو المكان بأنه هي وقعت وزحلقت للعطل وضرر إلها. إحنا دائما نقول أكو قضيتين، قضية البلات وقضية العطل وضرر. هاي العطل وضرر بس هسه احتمال اكو مو اكو 100% بس احتمال اكو احتمال ما اكو
هالاسبوعين هذه الماضيه
بالضبط.
Okay, now why might she and why might not she? Because in this situation there's still something called comparative fault in Michigan. Okay, and remember how we said the open and obvious defense, the court used to use that to say there's no duty by the premises owner to maintain their property. Well, guess what? There's now a duty, but then the question is, did they breach their duty? So let's say the snow just fell 5 minutes ago. Okay, it's literally snowing right now. Can a property owner clear their entire property in the 5 minutes between this time that the snow has started to fall?
Yes.
Okay, and the time that this person stepped out of their vehicle and slipped on the snow? The answer maybe is yes, but maybe it's no. And so the question, remember that each premises liability case has a duty, breach, causation, and damages. If the property owner doesn't breach the duty, in other words, maybe they couldn't have gotten to maintain the property in time, or under the circumstances, it wasn't reasonable to clear the snow because the snow was still falling. Okay,
you don't have what time,
right. So the question isn't now, though, whether or not they have a duty. The question is now whether they breach their duty. So in other words, does the person have a claim? Well, the answer now is maybe. Before, it was pretty much no, right? So at least now there's the possibility that a person can have a premises liability or slip and fall claim against that business.
اوكي مثل ما قلنا بانه قبل اسبوعين اذا الشخص وقع وتزحلق وطالع من السياره بنزين خانه، ما كان عنده الغاز ستيشن، ما كان عنده قضيه مال بانه هو ضد الاونر مال البنزين خانه، لانه فشي واضح وموجود. هسه احتمال مثلا خلينا نقول البنزين هسه وقع بالقاع، لو اكو دهن هو يعني همينه جديد، لو اكو ثلج والثلج هسه ولا ينزل
بعده
بالضبط. هاي اكو وقت الكل شيء. ابو المحل ما كان عنده علم، لو ما كان يقدر بوقت هالوقت المحدد بانه يقدر ينظف مثلا البنزين خانه كلها مره واحده.
لا.
لازم ما يدري البنزين هسه وقع، يعني فاحتمال واحتمال لا، يعني يعتمد على شو وقت صارت الضرر.
طبعا ما باقي لنا احنا الا كم دقيقه، دقيقتين 3.
We have just
Yeah.
we have just 2-3 minutes. We have to
wrap up.
not only
You're telling us we got to wrap it
No,
up.
we
I
can-
gotcha.
we can say our last.
Last
Sure.
words. Okay.
Last words.
I do actually have some last words, some important last words this week. So I want to give a task to the listeners.
Yeah, what's
Some
this?
homework.
Homework.
Yes.
Okay.
المحامي لورنس يريد ينطي
سؤال يعني بحسب نعتبره او فالدرس
عندهم واجب لازم يسووه
لازم يسوي. شنو
اذا
هو؟
يقدرون.
شنو هو؟
Yeah. I want everyone to spread the word about this case, and I'll tell you guys why. So obviously, in our community, there are a lot of business owners, a lot of store owners, a lot of gas station owners, a lot of shopping center owners, and frankly, even homeowners.
Absolutely.
essentially.
Absolutely.
What I want them to do is call their agent, make sure that they have a good general liability policy, and I'll tell you why. You know, I've seen not all of these cases turn into big cases, but I have seen some of these cases turn into $1 million cases. And the last thing that you want is something to happen at your business and you don't have the proper coverage. And essentially what would happen is they would put a lien on your business, and that's not something that you want. Obviously, a $1 million lien on your business will
Destroy.
take your business down.
depends on what the business is, but it could
Yes.
essentially destroy your whole
Your
business.
business.
So
Yeah.
Yes.
for the extra little bit every month just to sleep at night, I want everyone to get the word out that there needs to be good sufficient general liability coverage on your business, on your home, and tell everyone that you know, please.
الواجب اللي يسأله المحامي لورنس لكم رجاء خبروا كل أصحابكم، كل أي أحد عنده محل، عنده جاز ستيشن، عنده بيت، عنده أي بزنس، خلوا مالتكم الانشورنس اللايبيلتي اللي هي مال عطل وضرر عالي، لأنه القانون تغير ويقدرون، وخاصة احنا بالجالية هواية عندنا ناس عندهم البزنس مالتهم الأكثرية. رجاء انتبهوا، راجعوا مالتكم الانشورنس، هذا فشي جدا جدا مهم.
يعني ذكروا لهم انه اذا
بالضبط.
واحد وقع يمي شو اسوي؟ تقول له لابو الانشورنس. يعني
No,
هذا
not
البسيط.
even
لا،
that. Even
مو.
before anything happens.
قبل ما يصير اي شيء هسه.
قبل
يس.
قبل حتى لا يصير عندك شيء.
I mean, you don't want to have $100,000 on your policy, and then you get there's a case that's worth $200,000. Now you're out of pocket for the rest of the money.
Yes.
That's not what you want to happen.
No.
Make sure you have good coverage. And people ask me how much coverage. I tell them whatever your business is worth. If you think your business is worth $1 million, get $1 million in coverage, because that way you're going to be fine either way. If something happens, it will not take you under, essentially.
Right. And I think maybe the last piece of advice is if people have been in a slip and fall in the last 3 years and they've been rejected.
Yeah, give us a call. I mean, it's a free call. We'll look at the case and we'll tell you if there's something we can do.
Exactly. Because, at this point, it has changed, right? I mean, this is a pretty big sea change in the law. So.
مستمعينا مشاهدينا الاعزاء، طبعا الوقت مالنا انتهى، فشو نقول لكم الى اللقاء طبعا، ونشكركم. Thank you very much.
Thank you.
مستمعينا مشاهدينا، طبعا انتهى برنامجنا، نلتقي بكم ان شاء الله الاسبوع القادم. الى اللقاء يا